I will now take the sedent for this meeting of the Planning Local Review Body held on the 11th of March 2024. The following members are present: Councillors Ali Callison, Jerry Convery, Colin Dewar, Gladys Ferguson Miller. Councillor Lise Frame is not present. Following members are present: Councillors Leslie MacDonald, Richard Nelson, Norman Ray, Graham Scott, and we have apologies from Councillor David Shearer. Thank you, and I'll now pass you back to the Chair for today's business.
Thank you, Stuart. Item number 1, any declarations of interest? Item number 2, minutes of the previous meeting, pages 5 to 12 in your pack. I'll submit these for approval as a correct record. Everyone agree?
Agreed.
Thank you. Agenda item number 3 is review of case in respect of planning application P211542. It's pages 13 to 400 in your pack. The item before us today is a notice of review from William Gallagher on behalf of Greenstone Noble. The applicant is asking the PLRB to review the planning officer's determination to refuse an application for planning permission for alterations to existing restaurant and formation of drive-through lane with associated works at 3 Leesburn Court in East Kilbride. Members will recall that this case was initially considered by the PLRB on the 11th of December 2023. At that meeting, the PLRB agreed that the consideration of the review be continued to invite further written submission from the applicant, Roads, Transportation and Fleet Services and Transport Scotland. A further meeting was subsequently held on the 12th of February 2024. At that meeting, the PLRB agreed that consideration be continued again to hold a hearing to hear further information from representatives of the applicant and the Roads, Transportation and Fleet Services in relation to the potential impact of proposed development on the local road network in terms of road safety. Prior to starting the hearing, I will ask the planning advisor to remind us of the background to the request for a review to all the members. Tony.
Thank you, Chair. The site subject of the review comprises a vacant unit previously occupied by a Frankie and Benny's restaurant, and is located within a wider commercial area which is bounded by the A725 East Kilbride Expressway to the north and the A749 Kingsway to the west. The commercial area also includes 2 other restaurants, a tanning salon and also a hotel which also has its own restaurant attached to it. The proposal involves external alterations to the existing building together with the formation of a drive-through lane, and this lane would be achieved by reconfiguring an existing access to a service area to the rear of the building to form a double order point which would then merge onto a single lane around the side and rear of the building. And this lane would then exit via a new point onto Leesburn Court. The proposal would also involve the reconfiguration of the existing car park and the provision of some external seating to the front of the unit. The applicants have advised the refurbished unit would continue to be operated as a restaurant. As a result, a change of use of the building would not take place, and therefore this was not a matter before the case officer nor for the PLRB today. Statutory neighbour notification was carried out and the proposal was advertised in the local press. 2 letters of objection were received which raised concerns in relation to the impact on the road network, the impact on biodiversity and water quality, and the impact on a nearby nature trail due to littering. Consultations received in respect of the application are found on pages 39 to 48 of the papers. No objections were received from Environmental Services, and Transport Scotland did not advise against the granting of planning permission in terms of the impact on the local trunk road network, and that position has been reinforced in their response to a request for further comments, and these are found on pages 147 to 150. The Council's own Roads and Transportation Service did recommend the application be refused on road safety grounds, in particular that it would generate additional traffic when compared to the way the previous occupier of the building operated from the site, and that it would result in an increased frequency, length and duration of queues on the slip road from the A749 into the commercial area. The report of handling for the application is found on pages 29 to 38 of the papers. Section 5 of that report includes an assessment of the proposals against policy in National Planning Framework 4 and also the adopted South Lancashire Local Development Plan 2. And this concludes that the proposals accord with policies 1, 2, 9 and 27 of MPF 4 and also policy 2 and policy 9 of SLD, South Lancashire Local Development Plan 2. However, the report of angling concluded that the proposal was contrary to Policy 5 of South Lanarkshire Local Development Plan 2. Policy 5 states that in order to ensure that the development takes account of the principles of sustainable development, all proposals are required to be well designed and integrated with the local area. Proposals which should have no unacceptable significant adverse impacts on the local community and the environment. The case officer found that the alterations to the building would be acceptable and in keeping with the surrounding commercial area. However, based on the objections from Roads and Transportation, it was concluded that the road safety concerns meant Policy 5 was not complied with. And as a result, the planning application was refused on the following grounds. Firstly, the proposal is contrary to Policy 5 in that the installation of a drive-through facility at this location would generate additional traffic in comparison to the existing approved use at the site, and this would result in an increased frequency of queuing onto the A749 slip road and was therefore a road safety issue. Secondly, the proposal would generate additional traffic during peak times at a location that has already been observed to be unable to operate without impacting on the public road due to existing uses, and therefore the additional drive-through at this location would exacerbate this. And finally, due to the expected queuing on the A749 as a result of this proposal, this would impede the free flow of traffic and therefore generate adverse traffic congestion to the detriment of traffic and public safety. So this decision is the subject of the review before you today. As noted earlier, the PLRB agreed at its previous meeting that a hearing should be held to receive further information from representatives of the applicant and Roads and Transportation Services in relation to the potential impact of the proposal on the local road network. And therefore, I'll pass over to you, Chair, to start that process.
Thank you, Tony. I think it would also be helpful just if the legal advisor can remind us of the rules and procedures governing the hearing session today.
Thank you, Chair. I understand that the note of the procedure for today has already been circulated to all the parties before the hearing. Those procedures have been developed, taking into account all the regulations and the relevant circulars which relate to the hearing sessions. I'll just run through briefly what those the procedure will be. First of all, Chair, you will advise that all parties of the order that the specified matters and the attending parties will be heard following consideration. Each party will then be asked to introduce themselves and explain their interest in the review. Each party will then be allowed a total of 10 minutes to present their case as it relates to the specified matter. Once the first party has spoken, all members of the PLRB will be given the opportunity to ask any questions that arise. Thereafter, the second party will be invited to present their case, and members may ask any questions again that they may have. Once all of the parties have been heard, the Chair will open for members' discussion, and at that point in time, any further questions again may be asked of any of the parties that are attending. Cross-examination of the attending parties will only be allowed if the PLRB determines that that's required for them to make their decision. There's no right for the parties to cross-examine. On completion of the hearing, all parties attending the hearing will be asked to return to the public seats, and the PLRB will then decide if it has sufficient information to proceed, and if they do, the PLRB can then uphold, they can reverse, or they can vary the decision of the planning officer. If the decision is reversed or varied, the reasons and the detailed conditions required will need to be agreed by the PLRB, and if it's determined that further procedure is required, the PLRB has to determine what information they require, which party is required to provide the information, and what procedures are then to be followed. So that's a brief sort of rundown of what the procedure will be, Chair. If there's any other questions, I'm happy to address those.
Thank you. Having heard from our advisors, I would like to start the hearing, and I would ask all parties entitled to be at the hearing today to introduce themselves, explain their interest in applications, starting with the representatives from Roads, Transportation and Fleet Services. Can I now ask the applicant, I'll ask Roads and Transportation just to present themselves.
Good morning, my name is Stuart Laird. I'm the Transportation Engineering Manager here at South Lanarkshire Council.
Good Good morning, my name's Fraser Jack. I'm the Roads Development Management Team Leader. I've been dealing with the application for a few years now.
Thank you. And can I ask the applicant's representatives to introduce yourselves, please?
My name's Ian Miller. I'm from Cameron Rose Associates. I'm a highway consultant and transport planning and traffic engineering specialist, and I represent the applicant today.
Chair, my name is Heather Arnell. I represent Williams Gallagher on Town Planning Consultancy, who advise the applicant on town planning matters. I'm here to support Ian Miller in the matters of transportation and highways issues.
Thank you very much. I would stress that only matters that can be considered at today's hearing are in relation to the potential impact of the proposed development on the local road network in terms of road safety. The parties present here today have each submitted hearing statements to supplement the evidence that they will provide. All members of the PLRB have had the opportunity to read and consider these statements set out in appendices A and B in the papers in advance of the hearing. In accordance with the PLRB guidance on holding hearing session, each party has 10 minutes to present their case. I would suggest that members of the PLRB first hear from our Roads, Transportation and Fleet Services, and then, if considered necessary, take the opportunity to ask questions you might have about their statement. We can follow that by hearing from the applicant's representatives, and if considered necessary, take the similar approach to ask them any questions that we may have. After that, again, if considered necessary, members have the opportunity to ask final questions we may have to the parties represented. Everyone agree?
Agreed.
Agreed, thank you. Each party then has 10 minutes to present their case, and finally, just to remind members and the other parties attending the hearing, we have just determined questions that can only come for review body members. And the clerk will remind us 1 minute of the allocated 10 minutes. Mr Jack and Mr Laird, I may now present you to present your case.
Thank you, Chair. As with all applications of this nature, the planning application was submitted with various supporting documents. While assessing the application, a number of issues were identified, such as car parking numbers, the location of the drive-through exit from the proposed application site, the car park operation, which affects the car park access onto Leesbourne Court, as well as then onto the A749. All of this could have impacts on the surrounding road network in terms of road safety. Officers highlighted these and discussions have taken place over a length of time with the applicant, and it saw a number of additional parts of information, all of which is in your information pack today. From the consultation period, there was also video surveys that were undertaken, and these were undertaken over a period of a few weeks. The information has been used to allow Fraser's team to make a recommendation to colleagues in planning. There has been quite a substantial amount of information, and you'll appreciate there's been quite a lot of dialogue, both within the service itself, but with the applicant as well. So I'll pass over to Fraser, and he can run through some of the details of where our concerns are.
Okay, for this application, we've provided 4 separate responses as the application has evolved, each time raising our concerns around the operation of the proposals until ultimately we came to the conclusion that we were unable to support the application. It's worth highlighting some of the work that has been done to outline why we reached this conclusion. In each of our consultation responses, we raised concerns around the congestion in Leesbourne Court caused by the existing businesses operating within the retail park. Following our original response highlighting these concerns, the applicant's roads engineer, Transport Planning Associates, or TPA, carried out a queue-line survey to determine the extent of queuing in Leesbourne Court. These surveys found that on Saturday, the 6th of November 2021, in every 5-minute period between 16:40 and 18:30, a queue was shown to have formed from the car park entrance on the private access road, which extended out and or onto the public road. For clarity, the queue within that 5-minute period. Each 5-minute period may only have lasted for a short period of time. I would advise that the extent of the public road includes the mini roundabout and approximately 5 metres in towards the car park. The maximum queue recorded was 12 vehicles, which equates to approximately 72 metres, and the average queue was 6 vehicles, which equates to approximately 36 metres. To give this some context, a 12-vehicle queue is shown on page 259 of the agenda pack, and it may be useful to just have a look at that to see where the queue is shown to. This drawing was provided by the applicant's consultant, TPA, and shows the queue extending from the car park back to the splitter island on A749. And please also note the proposed location of the exit for the drive-through. In terms of the 6-vehicle queue, was shown to extend to the give-way line on approach to the mini roundabout, which forms part of the adopted road network. The applicant, over a period of time, has employed 2 consultants. The first, TPA, surveyed the queue lengths and confirmed the queue's length as described. The second, Cameron Rose Associates, did not initially agree with TPA or with their local knowledge of how the retail park operates. This resulted in further surveys being undertaken, which ultimately confirmed there is an existing issue with queuing at peak times. The results of these surveys were summarised in CRA Technical Note 02 on 17th of April 23. These results show that on 2 of the 4 surveyed Saturdays, the queues extend towards the A749, which align with the previously submitted queue surveys. This also qualified that TPA's and their understanding of the congestion issues within the retail park had been correct from the outset. In terms of the information provided, on Saturday, the 18th of March 23, between 17:47 and 17:57, the queue for the McDonald's drive-through had blocked entry to the car park. As a result, vehicles entering the car park or attending the drive-through had to queue in Leesburns Court. Between 17:48 and 17:54, the queue in Leesburn Court had extended through the mini roundabout and extended towards the A749. During this period, 2 vehicles overtook the queue on the wrong side of the road and performed a U-turn manoeuvre, whilst a further 11 vehicles overtook queuing traffic to enter the car park towards McDonald's. For clarity, this means that drivers would be on the wrong side of the road, facing oncoming traffic when passing the exit for the proposed drive-through. Please see photographs, which are screenshots of the video footage, and these are shown, it's images 1 to 10, and these are shown on pages 265 to 269 of the agenda pack. On Saturday, the 1st of April 2023, between 17:29 and 17:40, the queue at the McDonald's drive-through had blocked entry to the car park. As a result, vehicles entering the car park or attending the drive-through had to queue in Leesburn Court. Between 17:31 and 17:35, the queue in Leesburn Court had extended through the mini roundabout and extended out towards A749. During this period, 1 vehicle overtook the queuing traffic and performed a U-turn manoeuvre, whilst a further 10 vehicles overtook the queuing traffic to enter the car park. So that would also pass the exit to the proposed drive-through. But also if the queuing had not occurred, if the overtaking had not occurred, then the queue would be longer as well. I'd highlight that point again, that drivers would be overtaking on the wrong side of the road when passing the proposed drive-through exit, whilst potentially facing traffic leaving the car park. This results in vehicles either having to give way within the car park to allow vehicles travelling on the wrong side of the road to pass, or vehicles having to reverse back out onto the mini roundabout to allow vehicles leaving the car park to pass. There is the potential for a collision at this point, particularly as drivers leaving the drive-through would not necessarily anticipate vehicles driving on the wrong side of the road. CRA have suggested that the reversing manoeuvre does not occur, however it is visible in the video footage submitted, which is on images 1 to 3 on pages 265 to 266 of the agenda pack. Vehicles having to approach and exit a roundabout on the wrong side of the road and or travel onto oncoming traffic is a road safety concern, as it creates the potential for collisions to occur. Based on this evidence, it is evident that the queuing and congestion issues raised by ourselves have been evidenced. It is also agreed that the inclusion of a drive-through facility at the premises would increase the trip generation by up to 25 vehicle movements during the peak hour, noting that this is the best estimate based on a site in Salford and Manchester, which is similar characteristics, with a McDonald's nearby and situated on an A-class road and a small retail park. We would also advise that other fast food outlets at other areas within South Lanarkshire do cause known issues in relation to congestion at peak times, which has been a factor in our recommendation. Whilst the level is unknown, we are also aware of anecdotal evidence that suggests delivery drivers are being used more commonly. We therefore maintain our objection for the reasons discussed, due to an additional detrimental impact on road safety at peak times. This is because drivers have been observed overtaking the queue on the wrong side of the public road and car park access as discussed. These drivers would pass the proposed Tim Hortons drive-through exit on the wrong side of the road, which would increase the likelihood of an accident. Any increase in trips would make the current situation worse. And there's also a potential for increased occurrences of drivers on the A749, which has a speed limit of 50 miles per hour, choosing to drive to the retail park, but in realising the extent of the queue, subsequently decide to leave the deceleration lane. And this has been observed in one of the video footages and shown on page 270. The image isn't very clear, but the video footage shows the car leaving the queue. As discussed earlier, our role in the planning application process is to assess all the information provided and to use our engineering judgment and knowledge of the local area to ensure that any new development does not have a detrimental impact on road safety. We are of the strong opinion that a further drive-through facility within the Leesburn retail area will result in more drivers undertaking unsafe practices, particularly at the proposed drive-through exit, which will make the existing substandard situation even worse at peak times. Thank you.
Thank you, Fraser. I'm going to open up for any questions to members. If you would like to ask any questions to our roads and transportation, if you could please indicate now. Councillor Graham Scott.
Thank you, Chair. Before I ask my question of Stuart and Fraser, can I compliment yourself, Councillor Convery, and officers on having a hearing today? I know it's an exception and not the rule, but I think it's given the as one of the local members, given the complexities here and the issues, I think it's very wise to have it. And kudos to yourselves for, I know, as I say, it's an exception and not the rule, but kudos to you for having this event here today. My question to roads, and I'll go back to the delegated report, and I'll read a section of the original objection. Furthermore, this may also result in customers queuing to get into the estate, changing their mind and rejoining the dual carriageway at the off-slip, which has a potential to result in a vehicle collision on the dual carriageway given the 50-mile-per-hour speed limit. I take it that's another way of saying that you think that that would be dangerous to have a further drive-through in relation to adding vehicles. Am I right in saying that and obviously this is a current operation, that you deem the current operation at times, given the dates where you've done the exercises, you deem that to be dangerous?
Yes, Councillor, that is correct. It's a situation where... Yeah, that's correct. Where stationary traffic is essentially trying to move off into a lane of moving traffic, so that can be dangerous.
Begs my next question, which is obviously this is not the applicant's application, this is a current operation from, we'll say at McDonald's, who are operating the drive-through there at the moment. Has there been any consideration, given that you've accepted that it's going to be dangerous, has there been any consideration given to enforcement action to be taken against the current owners, given that they have an operation that on certain days is dangerous? Has there been any consideration given to that?
In terms of enforcement action, that's not something that, as a roads authority, we can do. That's an existing situation. In terms of managing that situation, then that is something that the more regular occurrence that happens, then it is a consideration that we would need to take that to the business owners within the retail park as well. It's not necessarily just one operator. There are other sort of fast food outlets within there as well that have got traffic going to and from the retail park itself that, as a cumulative impact, starts to create issues from time to time.
Thank you, Councillor Scott. Councillor Alec Allison, please.
Thanks, Chair. Excuse me. My understanding of what the roads of
Councillor Allison,
Stewart
can you try and
and
just bring your microphone close to you? You're just struggling to hear a little bit.
is that any better?
That's better.
Sorry. Where was I? Yeah, Stewart and asking Stewart and Fraser. From what I hear from what you say, the queuing traffic currently does not reach back on to the Kingsway. What increase in traffic would there need to be for it to do that? And secondly, in the past, we've been told that we can't legislate for bad driving. Is that not really what you're then looking to do here? Thanks.
Thank you, Councillor Allison. Stewart, Fraser? Fraser?
Yeah, in terms of the queue, what's been evidenced is that the queue backs to round about the Splitter Island. The expected queues haven't been calculated to any real extent. We've estimated that it would probably be around 1 or 2 vehicles extra that would be added to the queue, assuming the continued kind of practices occur. What that would mean is that people that were on the 749 would be able to see the end of the queue, and I think that's important bit because drivers would then kind of make their mind up as you leave the roundabout at what I would call the B&Q roundabout at the end of the expressway, and you turn left towards the 749 towards the Leesburn Court. It's quite open and visible, so people don't have a great deal of time once they're in the deceleration lane to make that case to go back out. So we think that that is a risk to road safety. Sorry, Councillor, could you remind me of the second question?
Yeah, in the past, we've had responses that we can't legislate for bad driving. Is that not what we're doing here by highlighting cars overtaking when they can't see a clear road ahead?
Yeah, that's what's happening at the moment, yeah. And the reason why we consider it to be a road safety impact for this application is because that practice would be made worse because there would be more trips going to the site. And again, if that bad practice didn't occur, then certainly the queue length would be longer again out onto the 749.
Okay.
Thank you, Councillor Allison. Any further questions?
No, I'm fine.
Fine, thank you. I've got a few questions myself, Stewart, Fraser, if I could just run through these. Driver behaviour, which some of the members have already asked already. We are always told from the Roads and Transportation that this is always a matter for Police Scotland. So can I ask what the difference is here?
In terms of driver behaviour, there's driver behaviour that occurs in the public road network, and there's the driver behaviour that occurs within the retail park itself. The retail park itself, when it starts to get congested, that's when you start to see, I'm going to say, bad behaviour from certain drivers, where they become impatient and want to enter different parts of the car park, or essentially get to a car parking space, avoiding the queue for the drive-through that's already there. There is a level of There is a level of drivers that are already overtaking, and I suspect that those drivers are associated with people employed by other businesses who deliver food out beyond the site, and I think it's those drivers that are causing some of the issues. In terms of driver behaviour and what police can enforce, that isn't a question I can answer here today, but certainly if there's bad driving practice, then that should be getting brought to the attention of Police Scotland to undertake enforcement action.
Thank you, Stuart. Can you tell me, from the notes, there's a mention of a handful of times. Can you actually tell me from that submission what that was used about for blocking the A749? A handful of times is not something that I've heard used by an engineer, and I'm just wondering what that actually means in terms of our roads and safety transportation.
Yeah, the reference to a handful of times was going back in time a while, and it was while we were trying to explain that we felt that there was an issue at the Lisburn retail area. It was based on knowledge of the local area, and it was essentially to explain that we felt that surveys would need to be done to try and evidence what our feeling and what our observations had been. You know, sometimes even before the plan application was lodged, we knew that there was queuing issues within Lisburn Court. So the reference to a handful of times is not quite a throwaway comment, but it was just to try and explain to the applicant that we were aware of issues there.
Thank you. And just further on to that, from the throwaway comment, as you probably used there as a handful of times, the second one was, concerned me, was about an engineering judgment. Is that a professional term? Is it a loose term? Is this always used within our roads and transportation? Is it normal practice to use an engineering judgment rather than an engineering tool? I know we have planning judgments, but I think from an engineering point of view, it's either a clear picture of yes and no. So can you explain to me what an engineering judgment is actually used, and how often you actually use an engineering judgment to ascertain an application for refusal?
There's many instances where the different complexities to a particular issue come into play, and that's where officer experience in dealing with applications is of use. So in this particular instance, as engineers, we're looking at guidance that's given within various engineering documents that are nationally applied. We're looking at movements to and from a particular retail park in this instance, and we're using a judgment on what we're visually seeing and comparing that to our experiences in other similar type applications that we've been dealing with, or at a wider scale looking at our road safety implications when we're looking at particular sites and locations as well. So in terms of the term engineering judgment, it's our overall experience in dealing with similar applications in this particular case, or similar situations.
Thank you. So it's definitely something that you use often, and something that you would think would stand up in a court of law, that to say that your engineering judgment is something that you use to determine an application.
I'm certainly not a lawyer, so I can't say what would stand up in a court of law, but certainly when ourselves as a local authority are making a recommendation, then we certainly use our engineering judgment when it comes to looking at all the factors and trying to determine whether an application in this case has a particular impact on road safety. Fraser's demonstrated to you today that through this body of work that's been undertaken by the applicant, that there are times when road safety issues arise, and we're obviously looking at those details when we're making our recommendation back to the planning authority.
Thank you. The last question is about the drive-through itself, and I suppose that's your major concern, is just the drive-through, because I know from the observations that if it was just a restaurant, then there'd be no objection from the Roads and Transportation. I suppose looking at that part, is that the main concern that you have? And then following on from that, is there any other way that we can look at the site? Is there any other land roundabout that we can perhaps look at to make sure that we get this drive-through in safely? Thank you.
Yes, you're correct, Councillor, in terms of the drive-through aspect. The restaurant could open just now as it stands. I think certainly if the restaurant was open, the queues would be longer, but I think specifically on the drive-through aspect, the location of the exit for the drive-through is very close to the mini roundabout, and that's where we've seen through the video footage that cars are overtaken on the wrong side of the road at that point. So you could have a scenario whereby someone's trying to leave the drive-through exit, the drive-through restaurant, looking to turn left, and they've got an oncoming car on the wrong side of the carriageway. So that's the sort of road safety element there. And obviously with the drive-through, by its nature, there will be additional trips. And I think we've generally agreed that the increase in trips would be somewhere between 9 and 25 additional trips, and that's based on evidence that's been provided by CRA and our assessment of that as well.
Thank you. Jerry, do you have a couple of questions?
Yeah, thanks, Chair. Can I ask Stuart and Fraser? So basically, you're asking the committee to refuse the application, and it's basically based on a road safety issue. That's the guts to your argument. Is that correct?
Yes, Councillor, that's correct.
Yeah. Could I? And you're also, if I take you back to Monday the 11th of December 2023, not the latest bundle of paper we've got, but the first bundle of papers we got, you've also got a concern about the road trunk network, haven't you? Traffic going on to that. Is that a fair analysis?
The concern is it goes on to the A749.
Which is the trunk road network?
That is not part of the trunk road network.
No,
it's
but
part of the local authority road network, yes.
Yeah, but it all merges together eventually.
It would do, yes, but not the trunk road network is separate from that.
Yeah, because would it be fair to say that Transport Scotland have no concerns regarding the application, in the sense you would think, again, they're a very, well, they're a national organisation, and yet they don't seem to think the same as my colleagues in the Roads Department in South Lanarkshire Council. But what I would like to ask, that's based on you guys are senior officers and you've worked in roads for a long time. Could somebody answer me this question then? How come when you've done a road safety audit, and I'll just read what it says, you've done a road safety audit, i.e. your department, with regards to the drive-through, a road safety audit was undertaken, and the only issue that was raised was the visibility of an exit sign of the drive-through, which could be addressed. Not once did the road safety audit say there was a potential problem with bad driving. I find that quite amazing. Could somebody give me an answer as to why we spent taxpayers' money on an audit, but it doesn't highlight what you two guys are sitting there saying is a major problem? Thank you.
Thanks, Jerry. Fraser?
The road safety audit was undertaken by the council. It was undertaken by the applicant. The reason for the road safety audit was to review the location of the exit from the drive-through in proximity to the mini roundabout, because we had concerns that it was too close. And I think it's a good example of the sort of engineering judgment that Stuart was alluding to earlier on, whereby there's nothing specifically written down in the guidance or documents that relates to how close an exit can be to the mini roundabout. We explained our concerns, and that was prior to the submission of the video footage. We have got it written down that we were unable to recommend a refusal on the basis of the location of the exit from the drive-through roundabout. However, what then occurred was the video footage, which we reviewed in detail, and it found that cars were overtaken on the wrong side of the road, which the road safety auditor wouldn't have had the benefit of that information. So that, just to clarify, the road safety audit was purely in relation to the location of the drive-through exit, and it wasn't to consider anything more than that.
Okay, thank you. Thank you. Stuart, are you looking to come in? And then I'll bring the applicants in.
Just very briefly, can I just clarify in terms of the trunk road network? The trunk road network that Transport Scotland are responsible for is the A725, and any queuing associated with this particular location would not queue back as far as the A725, and that's the reason why they have essentially said what they've said in the submission.
Thank you. Okay, we will move on to Mr. Miller. If you may now present your case. I don't know who will be speaking first. Mr. Miller, thank you.
Good morning, members. Thank you for inviting us to today's hearing. I am Mr. I. Miller, I for Ian, I-A-I-N, and I hold a postgraduate diploma in Transport Planning and Engineering. I have over 25 years' experience practicing traffic and transportation engineering in both the public and private sectors. To my left, I introduce Mrs. H. Arnell, H for Heather. Heather also holds a master's degree in town planning and has 18 years' experience practicing town planning. We have been retained by Greenstone Noble Limited, the applicant, with regard to application P/21/1542 to be heard today by this planning local review body. We are duly advised that the matters pertaining to the aforementioned application to be heard today are solely associated with 1. The occurrence and length of predicted vehicle queues associated with the addition of the drive-through lane at the former Frankie and Benny's restaurant at 3 Leesburn Court in East Kilbride. And 2. The impact of the proposed drive-through lane on the local road network in terms of road safety. No other matters have been put before this review body, and to do so at this time would represent the introduction of new information. On all matters, as you've said previously, Transport for Scotland raised no concerns with regard to the strategic highway network. With regard to queue occurrence, I refer members to the submitted summary report dated the 2nd of October 2023 by Cameron Rose Associates. This matter was first discussed between myself and officers of South Lanarkshire Council on the 26th of January 2023 on an MS Teams call. Mr. Laird, who is present today, stated during this meeting, as you already said, that he had observed queues blocking back onto the A749 a handful of times. Whilst not an arithmetic term, we considered as engineers that it would be appropriate to undertake further video surveys of the operational performance of the local network to establish, and again as you say, Chair, a clear picture. The extensive time parameters of the surveys were agreed with officers, providing us with significant operational evidence for Thursday, Saturday and Sunday over a 4-week period. Queues, as expected, were observed during the survey periods, but these remained largely within the site and rarely extend beyond the Leesburn Court mini roundabout. It is clear from the video recordings that queues rarely build on Leesburn Court, and on the odd occasion they do, they act as a slither queue and quickly clear. It should be noted that queuing vehicles adjacent to the kidney-shaped splitter island occurred for a total accumulated time of less than 1 minute within that 156 hours of survey data. The greatest period of slither queue duration alongside the kidney-shaped splitter island was for 10 seconds, or 0.001% of the total survey period. South Lanarkshire Council officers' email of the 17th of January agrees with these findings in that it states observed queues occur for a relatively short period of time. Given that it is agreed that the queues occur for a short period of time and the observational results do not show queues occurring on the A749, we can now turn to understanding the quantum of additional vehicles that would be attracted to the site by adding on a drive-through lane to the former Frankie and Benny's restaurant. It is an agreed point that the inclusion of the drive-through lane at the existing restaurant would result in a total two-way traffic attraction for the site of 66 vehicles, as to the former Frankie and Benny's building. Questionnaire surveys undertaken in 2023 at coffee drive-through facilities in Ayr, Dunfermline, Broughton, Paisley and Washington identified that 13% of customers said if there was no drive-through at the coffee restaurant, they would not visit the site. Therefore, by not allowing the drive-through lane at the site, a reduction of only 9 two-way movements could be expected. That is to say, by permitting the drive-through lane, we are accepting 4 to 5 more vehicle arrivals in the peak hour within the site, than what the site currently attracts. This equates to 1 additional vehicle every 12 minutes. Highway officers incorrectly referred to a figure in the original plan application submission, which relates to ancillary hot food sales to be sold from the former Frankie and Benny's when compared to McDonald's or similar hot food takeaway providers. This is not relevant to the amount of trips that could be diverted to the building from the nearby drive-through, and results in that 9 additional two-way movements becoming 25 additional two-way movements, which is 13 additional arrivals during the peak hour, which again equates to a very minimal 1 additional vehicle every 5 minutes. Members, I'm sure you'll agree with me that given the longest queue recorded lasted for a 10-second period, can we really conclude that either 1 additional vehicle every 5 or 12 minutes is going to add to queue length significantly and thus fail the Policy 5 test already presented? On the matter of traffic safety, the only evidence before you today that is presented in Technical Note 4 by ourselves, Cameron Rose Associates, and, as you said previously, the independent road safety audit submitted to the planning file. Members, no accidents have been recorded at this location for 24 years, and that's the period for which data is available. Furthermore, the independent road safety audit, as you say, did not find any issues with the operation of the local highway network in terms of accommodating traffic associated with the proposed addition of the drive-through lane. Technical Note 4, by ourselves, calculates based on Transport Research Laboratory papers 184 and 281, and we've provided copies of those, that it would take 312,500 peak hours for 1 additional accident to occur at the A749 priority junction, and 1 million peak hours for 1 additional accident to occur at the mini roundabout. Again, does this really fail the test of Policy 5? Members, no evidence has been provided by officers with regard to traffic safety. In their email of the 17th of January, in response to the question you raised at the first meeting of the PLRB, officers simply repeat the previously submitted information from their statement of observations. The only additional information officers present is an observation that only 11 cars in the 156 hours of data conduct an overtaking manoeuvre. An overtaking manoeuvre which is legal and supported by excellent, unfettered forward visibility. I'm sure members are in agreement that we should not be seeking to vilify overtaking manoeuvres where it is safe and legal to do so in order to support an emotionally loaded motivational bias. This simply cannot be categorised as bad driving. It's perfectly legal. Finally, members, this application does not seek to change the use category of the site. It will remain in Class 3 and therefore cannot be used for primarily for hot food takeaway. In any event, the site is not formatted for such an operation and therefore is only ideal for a coffee drive-through facility in the development market. My colleague and I would welcome any further questions members of South Lanarkshire or officers may have to clarify the submitted information. In the meantime, I respectfully ask that the local planning review body overturns the decision notice and allows this review and grants consent. Thank you very much for your time.
Thank you very much. I'll open now for any questions to members. If you indicate now if you would wish to ask any questions. Jerry?
Mr Miller, could you maybe, I want to dwell on this because I think it's, to me anyway, it's the most important thing. Going back to the road safety audit, which was commissioned by your own company or company representing Tim Hortons, and the answer for the officers of the council. I've read these documents. I don't see, at any time did you ever receive a report from the council criticising the road safety audit that you've done or making any observations about the road safety audit you ever done? Thank you.
Thank you, Councillor. And yes, quite correct. The safety audit, as you say, has never been contested. And the findings, as you say, only refers to visibility from the drive-through lane, which was then further addressed through further submission plans at that time and was resolved. The terms of a safety audit are defined by Design Manual for Roads and Bridges, and it's a standard of GG 119. Previously, HD 1915, and this is represented in the safety audit terms of reference. Now, safety auditors and members, I'm sure you've all seen safety audits in the past. Safety audits are a very heavy-handed tool in the assessment of development proposals. It is not for a safety auditor to ignore issues on the road network if they see them. They are assessing the proposals. They're not assessing specifically, in this case, a drive-through lane exit. They are assessing the proposals. They would have received the pack of information that the application was submitted with, the drawings, the transport statement and the such. So they have all this data. They also conduct daylight and nighttime surveys. And as you say, Councillor, in all cases, they don't raise any issues of road safety concern. Is there queuing? Yes. Is there overtaking? Yes. That in itself does not fundamentally demonstrate a road safety issue. And that is backed up and supported by the lack of any road traffic accident records. Thank you.
Councillor Alec Allison.
Thanks, Chair. I wonder, could you look, do you have access to page 388, Mr Muller? I don't come from East Kilbride, and I would like just to first of all get a picture of how this is going to operate. I take it the building you're talking about is the one with Indigo Sun on it. Could you please give us a layout of the traffic movements that you're anticipating?
Councillor Allison.
First question.
Building is across from Indigo Sun, but I'll bring in.
So it's the one on the right-hand side?
Yeah, it's the one on the right-hand side. You come in, it's on the right-hand side, but I'll ask Mr Miller just to...
Right, okay. Sorry, it wasn't clear. My apologies.
I think there is other drawings further in the pack. That show
I have been through it. This was the only one. Right, okay.
Mr Miller, would you like to come in with anything there?
Thank you, Councillor. Yes, as you say, the site layout and the site layout that is presented identifies a number of units. Hopefully it accords with the plan I've got in front of me as well, in that there is Unit 1, and that is the Indigo Sun unit, and that's on the left-hand side of the access road as you come in. You've then got two smaller units, which we've termed Unit 1A and 1B, which are Subway and Domino's Pizza. And then behind that, you've got Unit 2, which is the McDonald's. So they're all existing and will remain so.
Right.
The building we're referring to is the currently empty, unoccupied former Frankie and Benny's restaurant site. And as we say, this will remain a restaurant site. It will just have this additional drive-through lane. So the vehicle movements associated with this are entirely as defined previously. So they would enter Leesburn Court, turn left at the mini roundabout, enter the car park, and then enter the car park site and manoeuvre right into the drive-through lane. And the drive-through lane would wrap around the building, the existing building, and exit on the access road just before the mini roundabout. And the exit position is, as officers have identified in their information, partially within the adopted highway. Of course, the exit of a private road or private lane, a private driveway, a private drive-through lane, exiting onto an adopted highway is perfectly permissible and is acceptable.
Right. Thank you, and again, apologies for not finding that out.
That's fine.
Prior.
So if you look at pages 55 to 61, you actually see some photographs of, and the page from 55
Right.
to 61, you'll see an actual plan there as well, which may be helpful for you
Right.
to have a look at.
Okay.
Is there any further questions? From
No,
other
sorry,
members?
sorry, Chair. I had a couple of others. That was just
Carry
the
on.
first. So, therefore, in this drawing that was put forward showing the queuing back onto Leesburn Road, which we've identified would be for a very short period, what is therefore causing that queuing at the moment? Because there does not seem to be anything in the car park to stop vehicles keep moving or queuing.
Thank you. Correct. The operational performance of the car park in all the video information accords with what you're saying there. There is no sort of congestion within the car park. The queuing relates to the McDonald's drive-through, the single drive-through operator at this location. Excuse me. And this goes to the point of what we're presenting in our data, is that the traffic attracted to the current restaurant and the current restaurant with a drive-through lane is not all new traffic. Some of it will be pulled over from the McDonald's. So one might not visit McDonald's to go and get a coffee. One might visit this site for a coffee and a panini or something in that regard. So it provides an additional offer. It doesn't attract significantly more vehicles. Now, we term these primary and non-primary trips, and officers agree that these non-primary trips, these trips that are already there, are of a high level. Now, we disagree as to what number that might be. We say 9 two-way movements. The officers say 25. Either way, as I've already demonstrated, that's one additional vehicle every 12 minutes, one additional vehicle every 5 minutes. And that is what would be joining the back of the queue when it queues, and these short periods of the queue that occurs. The queuing does not occur all day. It is only sort of peak hour queues that we see on the highway network, entirely consistent with highway networks, and lasts for a very short period of time. And you'll note in my presentation, I referred to slither queues. These are slither queues. These are queues where the stationary period of traffic is milliseconds and the queue moves on. And we've all been in those queues as you sort of slide forward, hence the term slither queue. There's also another fundamental principle which the officers themselves recognise in the questions that they received. In that, if the vehicles are queuing to the kidney-shaped splitter island, which I say does occur, but for very short periods of time, and the longest period of which was 10 seconds, drivers coming down the A749 can see that end of queue and can make a decision. Now, this is a fundamental principle of traffic engineering. This is what's called the Wardrop equilibrium. It is the use of drivers' minds to determine where they want to be on the network and make a decision. No driver seeks to sit in a queue. I know we're British and we love all sitting and finding queues to sit in, but generally as drivers, we avoid them. So we make a decision and we go elsewhere. So there's also that factor to consider. So in answer specifically to your question, it is the McDonald's drive-through that backs up, but this in itself doesn't cause a significant problem for the use that we're proposing here with the addition of the drive-through lane.
Thank you. And Councillor Alison, have you got any further questions?
Final question to Mr. Miller. what time, excluding queuing time, would you expect a car to take to go through the drive-through? Does that make sense to you?
It does. Thank you, Councillor. Myself, I built a mathematical model that's used nationally now that assesses exactly this, is how long will a drive-through lane be? And the drive-through lane then has to accommodate that number of vehicles. And that's based off a Poisson distribution model. The delay time that we factor in for a coffee drive-through use is 5 minutes. That's within the model. Now, that's very, very robust. I'm sure members, you have been through coffee drive-throughs. They are now quite common in the UK. And the delay time is less than 5 minutes. But the 5 minutes gives us that nice, robust assessment. So that's what we derive that delay time on. And that then gives us a factor of queue length occurring.
Thank you.
Thank you, Councillor Allison. If there's no further questions, I've got some questions myself, Mr Miller, if I can just go through them with you. You'll note that from the submission from Roads and Transportation that they have the disagreement about the drive-through, and what would a restaurant create if it was only a restaurant only with no drive-through? Do you think it would still create the same issues?
Without the drive-through, Councillor, we say that the traffic would reduce by 9 two-way movements. Okay, so the Frankie and Benny's facility with the drive-through will attract 66 two-way movements in the peak hour, and that's agreed with officers. We say without the drive-through, you will reduce that by 9 vehicles. Okay, so we're going from 66 to 57, is it? Can't do my maths this morning, 57. Two-way movements. Two-way movements. So this is, as I say, 4 to 5 arrivals in the peak hour. And that's what we're dealing with here, is 9 two-way movements. So, no, there's the same situation that, you know, we can't possibly say that 4 or 5 additional vehicles in the peak hour is going to be significant and fail the test, the very robust test of Policy 5.
Thank you. Driver behaviour is something that Roads and Transportation had picked up pretty well, and you made reference to it when you first started answering your questions. Can you just tell me what you think of the driver behaviour and if this is what you perceive to be the main reason for the refusal?
Well, it's interesting in terms of the main reason for refusal. When I got involved at the beginning of 2023, it was clear that the concern related to vehicle queuing. And all the information we provided and assessed was about vehicles queuing and the impact of vehicles queuing on the network and the delay that that would cause to drivers. And you recall that in the first PLRB, all the information provided to that review body was about vehicle queuing. Now, the reason for this being is because highway safety was never raised during the meetings I had with officers, never raised. And indeed, in the last meeting I had with highway officers, and we couldn't reach an agreed position, and the application was therefore deemed to be refused, I made the point that the application and the decision notice should not reference any term to road safety, because the matter that we'd been discussing and they were concerned about was queue length and operational performance of highway network from a driver delay perspective. So no, safety was never a matter. So let's turn to driver behaviour. We have to be careful with driver behaviour. The rules of the road are the rules of the road. If we have got a broken white line, we can overtake. Where do we overtake? Well, we overtake on the opposing running lane. That is a manoeuvre. That is a legitimate manoeuvre that we can perform as drivers. We can't simply say, you can't do that. You can't do, if there's a double white line system, no, you can't do that. That's bad driver behaviour. But if there's a broken white line, where's the bad driver behaviour? Members, I'm sure you've overtaken vehicles in the past. Would you consider yourselves bad drivers for overtaking vehicles? No, simply not the case. If there's poor forward visibility, and it is dangerous to do so, we implement a double white line system as traffic engineers, and that prevents vehicles from overtaking. You could go one step further. On a private road such as this, you could put the double white line system in and put the soft pad bollards down the centre of the road. And that would crush when you strike them. So there are mitigation measures, but none of those mitigation measures are implemented at this site. Why? Because it's not dangerous. How do we know that? Because there's no accidents. None of these mitigation measures were discussed with highway officers. They never raised them as saying, this is a problem, how about this as a solution? And this is where I've struggled right from the outset of my involvement in this, that there has been this sort of engineering judgment, if you wish to call it that, but it's an emotional bias, it's a motivated bias to say, no, this doesn't work. As an engineer, I like to ask the question, why doesn't it work? And once we've established why doesn't it work, how do we solve it? But at this point in time, we have never established why it doesn't work. Because overtaking occurs, but overtaking occurs safely. Thank you.
Thank you, Mr Miller. In regards to the drive-through, is there any other pieces of land that you know about that you talk about making this work? From your perspective, is there anywhere that we can do something different that would allow you to come back with something that was more amenable to roads and transportation? Is there anything in there that you, from your perspective, that you can do to do that?
Thank you. And this goes to the reason I originally became involved in this application. As officers pointed out, there was a company called TPA originally acting on this site, and I was brought in to peer review the information and establish, A, is there a problem, B, is there a solution? Well, as I said, I never got past A particularly in that I couldn't see what the problem was. But if we were saying, if we just take it on face value that from an engineering motivated judgment perspective there is a problem, B, how do you solve it? And we did look at this and look to see whether there was any sort of mitigation measures one can provide within land owned by the applicant. And the answer to that was no. And we did a series of drawings that looked at this, and they were internal drawings. I think you'll see that information before the board starts at technical note 2. Well, technical note 1 was exactly that. It was the internal document peer reviewing to see if there was any measure that could be provided. So we have assessed it, we have analysed it, we have looked at it. And no, there isn't any land that can be provided. We have recommended that we redo all the road markings because they've all worn, and that would help enforce some of the give-way points and the such. We could even upgrade the broken white line to a double white line system, so it's not broken anymore. We could do that. That is an option. And then, as I said, we'd be reliant on that concept of the wardrop equilibrium of managing that queue length, which occurs on our national highways. So specifically, no, there is no land available to us. No, there are no improvements to address a problem that we don't know what that problem is, if that makes sense.
Thank you. Any further questions for the applicants? Thank you. Now that part of the hearing session has concluded, can I ask that the Roads, Transportation and Fleet Services representatives and representatives of the applicant return to the public gallery, and both parties are welcome to remain at the meeting and hear the review body's deliberations. Thank you. As we've been going for some time, it is my thought to have a recess until 11:50. If we can come back at 11:50, we'll have a recess to allow for a toilet break, and we'll come back for the decisions. Thank you. back to the PLRB meeting. We'll go into the review. The item before us today is a notice of review from Greenstone Noble. The applicant is asking the PLRB to review the planning officer's determination to refuse an application for planning permission for alterations to existing restaurant and formation of drive-through lane with associated works at 3 Leesburn Court in East Kilbride. As stated earlier, members will recall that this case was before them at the meeting with PLRB held on the 11th of December. The PLRB decided then that it did not have sufficient information to allow it to determine the review and that it wished further written submissions from the applicant and Roads and Transportation Fleet Services, advising on the impact of the proposed development on the local road network in terms of traffic safety, and from Transport Scotland advising the impact of the proposed development of the trunk road network in the vicinity of the site. Submissions were received from each of the parties. In addition, the parties were given the opportunity to review and comment on the additional submissions of other parties. These are set out in appendices 8 to 13 in the papers. Furthermore, at the meeting of the PLRB held on the 12th of February 2024, the PLRB decided that it wished to hear additional information from representatives of the applicant and Roads, Transportation and Fleet Services in relation to the potential impact of the proposed development on the local road network in terms of road safety, and this has now been completed. The PLRB now has to consider and decide how to proceed with this review. The applicant had requested that a hearing session be held and had not requested any further procedures. Taking account of what in our papers today, a previous decision relating to further procedures and the hearing session, we have to decide whether they do in fact contain sufficient information for us to determine this review, or if we need more written further information, a hearing or a visit to the site. I think having all that information we have, including the detailed photographs of the site, the evidence provided in the hearing session, that does provide us with all we need to consider this review without any further comment. Do we all agree?
Agreed.
Agreed, thank you. Members therefore agree that we can proceed without a site visit, further hearing and additional information. I am now going to open up the review for discussion. Can I open up for any discussion? Councillor Graham Scott.
Thank you, Chair. First of all, thanks to both parties, the Roads and Transportation and Mr Miller, for his presentation. I think they were excellent presentations, and thank you to both parties. As one of the local members, I'm obviously conflicted on this in some ways. That obviously knowing the old Frankie's and Benny's building, I'll be very kind to it and say it's a bit of a ruin at the moment. And certainly some economic activity there, such as jobs, Tim Hortons, a nationally known brand would be of benefit. Also, as a local member, public safety, and there's not an elected member sitting round on this PLRB that doesn't have public safety as an absolute paramount principle in terms of adjudicating anything. So on that level, I have to be happy in my own self that what my thoughts are not a danger or could not be dangerous to the public in any way, shape or form. Having listened to both presentations, and the stat that I picked out was from Mr Miller, there hasn't been an accident here in 24 years. As a local member, I've not. If we took the roads case, the situation there at the moment is so dangerous. I've not had one constituent come on to me saying that there's a dangerous situation there. Not one. Yet there's been no accidents here in 24 years. Yes, driver behaviour can be bad. Drivers are capable of doing anything, but on the basis of the information we have before us, I'm happy that certainly a consent there would not trouble me. Obviously, I'm prepared to listen to the views of other members of the panel, that I am certainly moving in that direction. Having said that, if we do go down the road of consent, I'd like to, hopefully, Chair, you could come back to me of a couple of ideas about mitigation as a local member, and obviously Councillor Ferguson Miller's on this PLRB as one of the other local members. I have some ideas in terms of mitigation that might be helpful if we could go down the road of consent. but I certainly wouldn't oppose this being a consent. Thank you, Chair.
Thank you. Any further observations, comments to be made? Councillor Allison.
Thanks, Chair. I've now looked at page 61. It didn't really answer the questions I was asking. What it seems to me from the information we've been given is that I'll be very doubtful if the queues will even extend, because the queues that are there at the moment are not being caused as backups from service. It's people deciding where they're going. 1 every 5 minutes. That is what the expected time it would take for someone to go through the drive-through. So I'm not sure that the backup in traffic is going to be extenuated. Always careful about health and safety issues. So if there are bits and pieces that can be done here, as suggested by Mr. Miller, I think we go ahead and condition them to do them. But the general principle seems to be sound. Thank you.
Thank you, Councillor Allison. Any further observations or comments? Therefore, I will summarise the points. The application then is for planning permission for alterations to an existing restaurant and formation of drive-through lane associated works at 3 Leesburn Court, East Kilbride. The adopted South Lanarkshire Local Development Plan 2 identifies the site as being within a commercial area where the principle of the location of restaurants, including drive-through facilities, are acceptable. However, we have to consider in this case whether proposals would have an inverse impact on road safety. If we consider that the proposal would have an adverse impact on road safety, then it would not accord with Policy 5 of the adopted South Lanarkshire Local Development Plan 2, and permission can be refused. Or, if we consider that there would not be an adverse impact on road safety, then there would be adequate justification for the proposals, and we could grant planning permissions subject to conditions. Our options here today are uphold, reverse, or vary the planning decisions. I will now invite for any decisions and the reasons behind those decisions. Okay, there is no Councillor Scott.
Yes, given the invite there, would it be correct for me to move that we grant a consent? Even though if we do grant consent, if you come back to me, I've got a few mitigating circumstances and conditions that I could possibly add, but I'll certainly move consent.
Thank you.
If there's a seconder, yeah.
Thank you. Councillor Gladys Miller, please. Oh, sorry.
Thank you, Chair. I agree with Councillor Scott to grant.
Thank you, Councillor Miller. Councillor Alec Allison, please.
I didn't press my button, Chair.
Oh, did you go back to sleep?
Thank you.
Thank you. Therefore, it is a decision. Sorry. I think just before we go on, it's been moved and seconded, and we take on board Councillor Scott's comments at the start of how everyone in the PLRB have a traffic and road safety to everyone, and that public safety. I would therefore ask, just before we go, Councillor Scott, to the next part of this, is that your reason for this, I would perhaps, without putting words into your mouth, you would therefore say that this accords with Policy 5 of the South Lanarkshire Local Development Plan 2, and therefore in taking account into that, what you also said was that there was no accidents in 24 years and nothing from the traffic audit. Without putting words into your mouth, can I just... Thank you. Thank you very much. Okay. Is there anyone else otherwise minded? No. Yeah. We have the conditions formatted and ready for, so I don't want to hold everybody for too long, but I would rather that you had a look at the conditions, given we have had this hearing today. So I'm going to ask and request that these are sent out immediately. And if we can reconvene here at 12:10, and that will give us about 5 minutes just to read over the conditions and agree the conditions. So we can meet back here at 12:10. Thank you. conditions set out by the application P211542. Are members happy to approve those draft conditions? Councillor Scott.
Sure if what I may be asking for might already be included or implicated into or implied in number 9 here, which is the interests of traffic and public safety. But I was asking, and I'm requesting, that extra white lines be put in, again, because obviously overtaking and the legalistics of overtaking were mentioned by both parties in the presentations, that to make sure and that everything is all above board, that we have white lines painted and the site clear in terms of where cars should go, if that's possible, Chair. It might already be implied in number 9, but if not, I'm happy to have it added if necessary. I think it would be an insurance policy in many ways.
Okay, thank you.
Double white lines, yeah.
Tony?
Thanks, Chair. My reading of condition 9 is it relates just the drive-through lane, which is round about the building, and it doesn't extend onto, I think you're talking about the public road?
Yes, well, yes.
Up to the mini roundabout?
Correct.
Yeah. So to my reading means it doesn't include that. So we would probably need, if members would agree, another condition to reflect that. However, I did speak to my colleagues in Roads just before we reconvened. Any changes to the public road, whether it's new lines or any other measure, would need Roads permission as well as road authority. So I don't think it's competent to have a condition to reflect that, unfortunately. But it would be perhaps to a discussion with Roads colleagues to come to a decision or an agreement on that.
Sir.
Yep. Sure.
Thank you, Chair. So that could be a matter for local members to take up with Roads Department.
Okay, you happy with that, Councillor
I
Scott,
will-
to take that forward?
I'll hopefully do that in accordance with the other local members as well, hopefully, yes.
Okay, all agreed? Everyone agreed then to happy to approve those draft conditions, including what the local member is going to take up with the Roads Department. Therefore, the decision of the PLRB is to grant planning permission subject to the agreed condition. The next stage is that a written decision notice will be issued by the PLRB, and this should be issued within 28 days. Item number 4, I have no items of urgent business. I will ask the clerk to stop the recording. Wish you all a good day and thank you very much for your attendance.